Welcome to the deep dive. Today we're taking a shortcut into one of the more stressful corners of digital law.
Definitely stressful.
Yeah, copyright infringement lawsuits,
hmm
specifically the ones that pop up from BitTorrent use.
Right. Often filed by entities people tend to call, well, copyright trolls.
Exactly. These suits can turn something seemingly small, like a download, into a full-blown federal court situation.
Yeah,
It's pretty intimidating stuff.
it really is. And it impacts potentially anyone with an internet connection. So we're looking at this through the lens of a very specialized lawyer,
Right.
someone whose entire practice pretty much is defending people and businesses across the country against exactly these kinds of suits.
And the specialization is clear from the get-go. This lawyer, licensed for 24 years.
Mm-hmm.
The firm, Antonelli Law, they've been deep in this specific BitTorrent copyright defense world since 2011.
That's over a decade of focus.
And get this, they've represented over 5,000 clients nationally, just in these cases.
5,000. That tells you something about the scale, doesn't it? This isn't some niche issue.
Not at all. It's a huge, ongoing legal battlefield.
And you see that scale in how their practice breaks down. About 80% of their work is copyright infringement.
80%.
Yeah, focused almost entirely on these copyright troll suits. So they've seen it all. Defended against filings from, over 50 different movie and software companies?
Including the really big one, Strike 3 Holdings, LLC.
Oh, yeah, Strike 3. They're probably the most active filer out there. Prolific.
So, for listeners maybe not steeped in legal jargon, let's unpack this copyright troll mechanism a bit. It sounds aggressive.
It is.
What's the actual business model here? Because it doesn't seem like they're trying to recover, the price of a movie ticket.
No, not really. It's about leverage. The key is the Copyright Act itself. It allows for something called statutory damages,
Okay.
which means penalties that aren't tied to actual proven loss. They can range from $750 up to $30,000 for each infringement.
Each one.
Each one. And if they can argue the infringement was willful,
Then what?
then it can jump up to $150,000 per work. So a troll might claim someone downloaded, say, 10 movies. They don't need to prove the downloader cost them money, just that the infringement happened. Then they waive the threat of potentially hundreds of thousands in damages.
To get a settlement of a few $1,000s instead.
Exactly. Maybe $3,000, $5,000. It's a business model built on the fear of massive, potentially ruinous legal costs. Coercion, basically.
And the first shoe to drop for the person at home is usually that ISP subpoena, right?
Yeah.
That's the moment it gets real.
That's the pivot point, absolutely. It goes from abstract to terrifying very quickly.
How does that actually work? What's the lawyer's role right then?
Well, the trolls usually only have an IP address linked to the download. That's it.
And numbers.
Right. So they file a lawsuit in federal court, often just against John Doe, a placeholder name.
Okay.
Then they ask the court to order the internet service provider, Comcast, Verizon, whoever, to reveal the identity of the subscriber assigned that IP address at that specific time.
And the ISP usually complies.
Generally, yes, if the court orders it. Once that name is revealed, the person faces a choice. Fight a federal lawsuit, which is expensive and public.
Or settle.
Or settle, which is what most people do or want to do.
So the defense lawyer steps in right there at the subpoena stage.
Ideally, yes. The first goal is often to manage that subpoena response. Maybe try to quash it or negotiate anonymity for the client.
Anonymity is key for many people, I imagine.
Hugely important. Or, if a settlement seems necessary, making sure it's done discreetly. And sometimes the person named isn't even the one who did the download.
Right, could be a kid, roommate, a guest using the Wi-Fi.
Exactly, which adds layers of complexity. You really need specialized experience in IP litigation to navigate that. The stakes feel enormous for someone facing federal court for the first time.
And this specialization, this 80% focus, it doesn't mean they only do this, right? There's that other 10% in related IP disputes.
Correct. About 10% involves other intellectual property issues. Things like someone's photo being used wrongly by a model agency or an image appearing on a gossip site without permission.
So they understand digital rights and copyright broadly.
Which definitely helps. That broader context informs the strategy, lets them see the systemic issues.
Like the ones they wrote about.
Precisely. It connects to their thought leadership. They're not just reacting to cases, they're trying to improve the system itself.
Let's talk about that 2013 article in the Illinois State Bar Association's IP Law newsletter. Torrent wars, copyright trolls, legitimate IP rights, and the need for new rules vetting evidence and to amend the Copyright Act. That title alone tells you they have strong opinions.
Oh, absolutely. It wasn't just a casual piece.
What was the core argument? What were they pushing for back then?
The main point was that the evidence trolls typically use is, well, pretty thin. Often it's just an IP address and a timestamp.
Which isn't definitive proof of who did the downloading.
Not at all. So the lawyer was arguing for stricter judicial rules. Courts needed to better scrutinize this evidence, challenge the whole chain from IP address to actual person. And they also called for changes to the Copyright Act itself to prevent trolls from abusing those huge statutory damages, especially when there's no real proof of willful infringement or anyone making money from it.
So challenging the very foundation of the troll business model.
Essentially, yes. And that thinking clearly informs how they approach defending these cases now.
Which brings us nicely to the results, the strategy in action. Because when people get that subpoena or lawsuit notice, they're stressed. They're scared.
Understandably, they hear about those massive potential damages.
And they often just want to make it go away, right?
Yeah.
Pay something, anything, for privacy and peace of mind.
That anxiety is exactly what the standard troll settlement process feeds on. But we see a real difference when specialized counsel gets involved.
How so?
Well, there's a client testimonial that's really telling. This person first consulted a different lawyer, described as prominent. That lawyer estimated a settlement cost of over $600 per movie title.
Per title. That adds up fast.
Very fast. And they pushed the client to sign up for an hourly rate within 48 hours, basically using the privacy concern as pressure.
The classic high-pressure, potentially high-cost approach.
Right. But then this client went to the lawyer we're focusing on.
Yeah.
The outcome was totally different. First, they worked on a flat fee basis for the settlement.
Predictability. That helps the stress level immediately.
Huge difference. And the final settlement amount. It was significantly less than even the minimum estimate the first lawyer gave.
Okay, that's a clear win. Flat fee, lower cost.
But the really powerful story, the one that highlights the outside-the-box strategy, involves another client.
Tell me about that one.
This person was facing a lawsuit called 6 other lawyers, general federal litigators, presumably competent folks.
6 different opinions.
And all 6 give remarkably similar advice. Expect a minimum settlement between $9,000 and $12,000.
9 to 12 grand.
Plus another $2,500 to $3,000 in their own attorney fees. So the client was basically resigned to paying around $15,000 total to make this go away.
Ouch. A $15,000 hit is serious for almost anyone.
Absolutely. They were ready to surrender, just pay it. But then they spoke to this specialist.
And the specialist said?
The specialist employed a different strategy. Something the client said was outside the box and blew their mind.
Okay, the $1 million or maybe $15,000 question. What was the result?
The case was settled for roughly a third of what every other lawyer had quoted.
A third. So instead of $15,000, maybe closer to $5,000 all in.
Something in that ballpark, yeah. A massive difference. It wasn't just shaving a bit off. It was fundamentally changing the outcome.
Oh, what does that outside-the-box strategy usually involve? What are they doing differently?
It often comes back to challenging the evidence, just like in that Torrent Wars article.
Questioning the IP address link.
Exactly. A general lawyer might see the huge statutory damage risk and just advise settling high to avoid that risk. But the specialist knows the weak points. How reliable is the tech they use to get the IP? Can they really prove the subscriber was the one clicking? Can they prove willfulness? Because that's needed for the really scary damages. By pushing back hard on those points, raising real substantive challenges.
Instead of just rolling over.
Right. They force the plaintiff, the troll, to rethink. Suddenly, going to trial looks risky and expensive for them. So they become much more willing to accept a dramatically lower settlement just to close the case.
That sounds like what their peers say, superior legal services at a good value.
It fits. And it makes sense of the endorsements praising their new and creative ways to defend these cases.
But let's play devil's advocate for a second. We talked about flat fees for settlements, which sounds great value. But the firm does list hourly rates from $250 up to $550 an hour. How does that fit in?
That's a fair question. For anyone listening who might be facing this, the initial consultation, the first 30 minutes, is free. So you get initial advice at no cost.
Okay, that's good to know.
The hourly rates. Those likely come into play for more complex stuff, maybe that 10% of their practice doing bigger IP litigation, or if a client actually chooses to fight the case in court aggressively rather than settling.
So Cases where a simple flat fee settlement isn't the goal or isn't possible.
Probably, but the testimonials strongly suggest that for the typical BitTorrent defense scenario, they push hard for that optimized flat fee settlement to keep costs predictable and low. The expertise is used to get a better, cheaper result, not to run up the clock.
That builds trust. And speaking of trust, especially when discretion is so vital, it helps that one client was actually referred by the Electronic Frontier Foundation, the EFF.
Yeah, the EFF is a major respected name in digital rights, so referral from their list of attorneys is a pretty strong endorsement of competence and ethics.
Definitely adds credibility. It lines up with the peer reviews, too.
And the client reviews. Those consistent AVO Client's Choice Awards, year after year from 2018 right through 2025. That shows a long track record of satisfied clients.
It paints a consistent picture. Before we wrap up, you mentioned another specialty, drones.
Right, briefly. They also have a drone UAS practice group with a national reputation. They were doing speaking engagements on that back in 2015, 2017.
Interesting. Seems niche, but maybe relevant.
I think it is. It shows a pattern. Mastering complex areas where technology meets federal regulation. That's exactly the kind of thinking needed to challenge the technical basis of these IP infringement claims. It's about understanding the tech details.
Okay, so pulling it all together, this deep dive, looking at this specific lawyer's profile and practice, what's the big takeaway?
I think it shows that in these really niche, tech-heavy legal areas, deep experience like handling over 2,000 IP cases in 14 years isn't just a small advantage. It fundamentally changes the game.
It turns scary, potentially bankrupting lawsuits
Into